what beautiful paintings. Who's the artist?
The Dutch master Rembrandt painted these in the 17th century. They are wedding portraits of Martin Solzman and his wife, Opium Coppet.
Oh, I think I've heard of those before. They haven't been shown to the public in a long time, right?
Exactly. They have been privately owned by the Rocheville family since 1877 and have only been shown once in the past 150 years. Fun facts about these portraits. In 2015, the Rocheville family announced the sale of the paintings. The Dutch government raised 160 million euros to purchase them both. But then, France entered the bid for one of the portraits. To avoid political conflicts and a potential bidding war, the two countries negotiated and agreed on a joint acquisition of the paintings.
But I thought it was illegal in France to have joint ownership of cultural properties.
You are absolutely right. For this reason, each country bought one portrait. The Netherlands owned the Martin portrait, and France owns the portrait of his wife. However, their contract explicitly says that the two countries would manage the preservation and security of the paintings together. The two portraits would always be shown side by side, alternating between the Louvre in Paris and the Rijksmuseum in Amsterdam.
That's fascinating. But what would happen if, say, the Dutch-owned painting catches fire per accident? If the Netherlands can't lend their painting anymore, would France still be forced to lend theirs on a regular basis?
That's a good question. Also a very peculiar situation. It surely would lead to an interesting legal case. The way I see it, France would probably claim the termination of the contract based on the doctrine of fundamental breach. This doctrine, defined by the Unidroit principles, states that a party is allowed to unilaterally terminate a contract in case where the failure to perform an obligation amounts to fundamental non-performance. To determine whether this principle can apply here, the courts dealing with the case would have to determine if the Netherlands is guilty of fundamental non-performance.
But to understand what the contract is all about, shouldn't one have to take into account the circumstances under which the contract was written, as well as the intention of the parties?
Yes, and the Unidroit principles include both of those. A contract shall be interpreted according to the common intention of the parties. To do so, one needs to take into account preliminary negotiations and circumstances. In our fictional case, there are 4 important points to consider. The first one is that the countries entered into an agreement because they have a shared interest to protect and promote European cultural heritage to as many people as possible. The second point is that their agreement promotes cultural cooperation between their two countries. The third one is that the Dutch government could have acquired both paintings but decided to enter into an agreement with France to avoid a bidding war. Finally, and this is a crucial point, the initial intent of both governments was to own half of the paintings each. However, joint ownership of cultural goods is illegal in France, as you mentioned before. The countries therefore decide to purchase one painting each. This decision doesn't reflect the intent of the parties, but rather their compliance to French law. Sorry, I'm getting a bit technical here. Basically, the essence of the contract seems to be the cultural cooperation between France and the Netherlands. So, the accidental destruction of the Dutch painting does not constitute fundamental non-performance.
Alright, I get what you're saying, yet, concretely, what would this mean for France and the Netherlands?
Well, France would not be allowed to unilaterally terminate the contract, and the Dutch would retain their claim on the management and the periodical exhibition of the remaining painting, Opium's portrait.
That's interesting to hear. You know, I always wondered how the law deals with situations where the written contract doesn't quite capture all the subtleties of the mutual agreement. So it's really interesting to see how the Unidroit principles take into account intent and circumstances when analyzing underlying contextual issues.
Absolutely. This approach promotes a less strict literal interpretation of contract terms and recognizes other important factors, which aren't written down but might have played a fundamental role in the negotiation process and contract agreement.
Makes sense. Thanks for the explanation. On a side note, it's such a shame that French law prohibits joint ownership of cultural properties. Museums often lack funding and find it difficult to expand their permanent collection. Being able to buy artworks with other institutions and split the cost and responsibilities would be such an invaluable tool.
You're right, that's such a good point. Hey, shall we go check the Vermeer paintings now? I've heard they have beautiful ones here at the Rijksmuseum.